Hello all, and welcome to the course session, Intersections Between Journalism, Law, and Rights. Joining us today are Dr. Javier Diaz-Nossi, Dr. Richard Damari, and Dr. Antonia Nogales-Bocio. Antonia Nogales-Bocio unfortunately had some personal issues she had to attend to, but she was kind enough to send us a recorded version of her presentation. So we're going to show that at the end of after the two speakers who are present have given their presentations. And of course, this means she won't be able to answer any questions the public might have regarding her presentation, but we can always put people in touch with each other. So I don't know if which one of you wants to begin, Richard, Javier, and I can do a little presentation.
I think it's Richard best because I'm
excellent.
the people from home.
Okay.
Excellent. So I'm going to give a little presentation as Dr. Richard Damari, Senior Lecturer in Journalism at City University of London, where he directs the master's degree in Investigative Journalism. He's a doctor in media law and has worked at the BBC and Channel 4. He's an expert at Columbia University's Global Freedom of Expression Project. He has been a consultant for the Council of Europe and the International Senior Lawyers Project in relation to teaching international freedom of expression law. His main research interests are international and comparative media law and freedom of speech law. And today he will be presenting the talk, Comparative Freedom of Expression Law and Investigative Journalism. Take it away, please.
Thank you very much. And thank you very, very much for inviting me. We were just saying before this was recorded how nice it would be if we were all sitting in a room in Barcelona, but that's not to be. Maybe next year when COVID is over. So I'm going to talk a little bit about this. I've got a slide deck. So here is the first attempt to get this to work. And bear with me if it doesn't, and I will try again. But hopefully you can now see just a single slide with nothing else as well. Is that what we can see?
Yes.
Good. So that's a summary of what we're going to talk about. That's the title slide. You can see just a little bit about me. I'm at City University, but I'm also a research associate research fellow, something to do with that, at the Institute for Advanced Legal Studies, also at the University of London. So I'm going to be talking about global freedom of expression rules and investigative journalism. And what I'm going to be doing is I'm going to be basing it on a piece of work I did a couple of years ago for this book. Now, this book is quite an interesting one. It came out of Columbia University, and it looks at global freedom of expression rules, which goes beyond media law, but other areas of freedom of expression and its effect. And ask the question, to what extent are there some emerging global norms about freedom of expression rules? And so I wrote a little bit about that, and I was looking at investigative journalism, a particular part of investigative journalism. The talk I'm going to give is based on that. So if you want to learn a little bit more about it, then feel free to go, and I'm sure it's in your library or could be ordered. And the other chapters are actually quite very interesting as well. Agnes Callamard used to be the UN Special Rapporteur for extrajudicial execution, I think, and now she runs Article 19. So, okay, so we're looking at rules, we're looking at international law rules, and we're looking at a particular sort of journalism, investigative journalism. So our first question is, what ways could these rules have an effect on investigative journalism? Because we're looking at laws and rights and journalism, the intersection between the two of them. So first question is, how can these things interrelate? I think there's three different ways, really. I mean, some rules which are obvious can hinder investigative journalism more generally, and some rules can help investigative journalism. So rules can prevent you from doing this and that, the other, and they can help it. So you can have the same rule which can do the same thing. A rule of privacy can get in the way of investigative journalism. And in some situations, the rule of privacy can help investigative journalism. I think that's pretty well understood. One which is less understood is that some rules can create, as in allow to happen, activities which they wouldn't be able to happen if those rules didn't exist. Now, that needs a little bit of explanation. So I've got a visual a guide to this. This, of course, is a piece of grass. Now, the difference between a piece of grass and a football pitch is rules. The difference between the two is that if you create a rule which says, for example, if the ball goes over this white line, then things happen, or if the ball goes between these wooden posts and something happens, you've actually created something, and you've created the environment for something to happen. And these are facilitative rules. This isn't, by the way, an idea which I've come up with. It's a man called H.L.A. Hart who came up with this idea. So these are general points to start with. When you're looking at the intersections and how the effect of rules have on a particular activities, it's important to recognize that the rules can stop an activity and can help an activity, but rules can actually create an activity which wouldn't exist if this didn't happen before. I'm not going to go through all the different ways, I don't have time, in which international law and rules more generally help or hinder journalism, but I'm going to take a particular element of investigative journalism. Now, let's look at investigative journalism and let's look at what it is. Ultimately, there's two things. You find out information and you communicate information. That's all a journalist does, or an investigative journalist does. And perhaps an investigative journalist will emphasize more finding out information than other people. So when we're looking at this intersection, you can't look at all of that either. So you need to narrow it down a little bit. So what I'm looking at is I'm looking at a particular subset of that. And I'm looking at the ability to protect your sources, because that's one of the key things which investigative journalists need to do. They need to protect their sources. Without this, and this is something a colleague and I wrote a while ago, ironically agreeing with Donald Trump, but without the ability to protect your sources, then the job becomes much more difficult. So it's one of those rules which is either facilitative or creative, allows the ability of investigative journalism to happen in the first place, these rules about journalistic source protection. So that's the kind of the introduction, that's the basics, and that's what we're looking at. So what are these rules? Now, I understand that there are some lawyers in the audience, and forgive me if I'm going over stuff now that you'll know a little bit about. And for others, forgive me if I'm talking about law, because law can sometimes cause people who are non-lawyers to think, oh my goodness, all of these rules. So I will try and make this as painless as possible. Let's look at some of the rules which exist to protect investigative journalism. Now, there are different sorts of rules to start with. There's legal rules, there's regulatory rules, and there's ethical rules. And of course, we are talking at the moment about legal rules, and we're also talking about international legal rules. It's worth, in passing, note that there are a huge amount of other sorts of rules which are worth thinking about when we're thinking about this intersectionality between rules and activity. Even when you're just looking at international law, there are a huge set of rules there. We're going to have a look quickly at the laws of the United Nations, but it's worth bearing in mind that there are a whole set of other rules which exist as well. So there's WTO law, there's domestic law with an international effect, and here I'm thinking about the United Nations, the United States' First Amendment to the Constitution, and not necessarily relevant here, but still important, is the European Union's right to general data protection regulation, which is a kind of a regional law with an international effect. But let's just look at the United Nations. There's Donald Trump again. Within the United Nations, there are a whole different sets of laws, just to complicate the picture, which can affect journalistic source protection. We've got the Universal Declaration of Human Rights. We've got the International Convention on Civil and Political Rights. We have the International Covenant on Economic, Social and Cultural Rights, and there are various other provisions as well. I'm just going to have a quick look at this. I only have a short period of time, so I'm going to have a quick look at what's called the ICCPR, the International Convention on Civil and Political Rights. Now, within this, there are two provisions which are particularly important when you're looking at journalism and you're looking at source protection. Article 19 and Article 20, of which Article 19 is the most important. And Article 19, I'm just going to put it up on the screen. I'm not going to read it out in a lot of detail, but to show you how it works there. It's quite an extensive provision. Compare it, for example, with the United States First Amendment. That says, Congress shall pass no law abridging freedom of speech or the press. You know, there's about 6 or 7 words there, not that many anyway, compared with this. This is more complicated. And it works in 2 ways. Article 19(2) provides the right. Everyone shall have the right to freedom of expression. This right shall include the freedom of seek, receive and impart information and ideas of all kinds, regardless of frontiers, either orally, in writing or in print, or in the form of art, through any or other media of his choice. So it provides people with the right. And then Article 19(3) provides exceptions to this. So it's not a whole or not an absolute right that's provided. It's a relative right, or it's a tempered right. And this means that obviously we need to think a little bit, or at least lawyers and judges had to think a little bit about how these two elements work together, the bit which provides the right and the bit which puts restrictions on the right. What it doesn't mean, as some people think when they look at this, that there's no protection at all. What it does mean is that a series of law has developed to try and work out how these two provisions work together. And this is quite common in many similar areas of international law. We're talking about the United Nations here, but it works the same. A similar sort of test exists in the Council of Europe's European Convention on Human Rights. And that there are three elements that all this breaks down to. The courts look at whether a restriction on freedom of expression is legal. In other words, it's passed into law according to what the local conditions are for what a law is. Second, if it's legitimate. So in other words, if it pursues a legitimate aim in restriction of the law. Now, the legitimate aims in the case of Article 19 are set out on the screen there. So you've got for the respect the rights and reputation of others, and the protection of national security or order, a public order, or public health or morals. So those are the legitimate aims. And the third one, legality, legitimacy, and proportionality. It needs to be the thing which is restricting the right. So the restriction on the right itself to freedom of expression needs to be proportional. In other words, it needs to be necessary to bring about the legitimate aim, and it needs to be not excessive. So that's the three-part test. What's all that got to do with journalistic source protection? The answer to that is that the organization which interprets or provides guidance on this threefold test is called the Human Rights Committee, and I'll provide these slides later on. But this will be recorded, and so you can't click on it, of course, but you'll be able to copy and see those links later on, and they provide you with an explanation of what the Human Rights Committee is. But for present purposes, the Human Rights Committee is an organization which helps us understand how Article 19 works, and its most important document on this is General Comment 34, and in it, Section 45 says, and here's going to be the red bits, that one of the things that the operation of Article 19 and the three-step test, one of the things which it needs to do is it needs to provide limited journalistic privilege not to disclose information sources. So that's where the law is. So this law provides, or at least those people who are signatories to this convention, this law provides some protection and allows and facilitates, to go back to the thing I was talking about at the beginning, facilitates the activity of investigative journalism. Now, that's one. Whistle-stop tour through all of this. There's quite a lot of law I'm going to take in passing, and I hope you're still with me. We've just had a look at the United Nations. I'm going to take you a couple of other places. I'm going to take you through a couple of other areas. I'm going to take you through some regional law and a little bit of domestic law at the end. And then I'm going to end up by talking about what does this all mean? What does this all mean about for the intersection between rules, laws in this case, and investigative journalism? So we're kind of at the halfway point here, you'll be relieved to know. So international law we've done. Let's have a look at the Council of Europe. The Council of Europe, as you all know, is not the European Union. It's a different body. Of course, one of the most important differences is, well, not the most important, but the significant difference for someone who lives in the United Kingdom is we've left the European Union, but we haven't left the Council of Europe. We're still bound by its laws. It's a different body. Now, the Council of Europe has, for many years, had a effective piece of legislation called the European Convention on Human Rights. And within this, there is a provision, Article 10, which protects the freedom of speech. Now, in the same way that we saw with the United Nations, in the terms of in the Council of Europe, this piece of legislation has been interpreted in such a way that protects source protection and therefore investigative journalism. Now, the way it's happened in the Council of Europe is slightly different from the United Nations. The body which interprets the this provision, Article 10, is the court. It's the court in Strasbourg, the European Court of Human Rights. And an early case, and this is a 1997 case, which has been deeply influential throughout the world, A good example of a norm exporter, the European Court of Human Rights, came out with a case based on the UK, originally a UK dispute. And this provided a very strong protection for journalistic sources. It said, and you've got the reference there at the bottom, that protection of journalistic sources is one of the basic conditions for press freedom. This bit's gone red. Without such protection, sources may be deterred, and the press wouldn't be able to provide their activity as a watchdog. So this is quite an important establishment of a rule which allows this particular activity, investigative journalism, to take place. Now, there's lots of other case law on this, and I'm not going to go into it, but if anyone's interested, then please contact me and I can give you some more reading on this. But let's move beyond Europe and let's look at other places. Let's have a look at the Inter-American Court of Human Rights. Now, again, the American courts have come up this less with I'm not looking now at a case, but I'm looking at a declaration. For various reasons, it's useful to look at this bit of law when I'm trying to talk about the intersection. So we've got this, which is a declaration which came out in 1994, and you can see the words there. No journalist may be forced to reveal his or her sources of information. So that's the American. So again, there's more law on this. This is a very quick tour through the law. Let's have a look at the African Court on Human and People's Rights. I'm choosing these partly because that covers a large chunk of the world's population, but also because to show the importance at the regional level of this rule, which is emerging. Again, we've got a declaration in 2002 here, which says that media practitioners shall not be required to reveal confidential sources of information, except in accordance with the following principles. And it sets out 4 tests there. So we've got, let's take a stock tech, we've got the United Nations. So we've got an international human rights law, which protects journalistic sources. We've got various regional courts and regional laws, which protect journalistic sources. Let's look at another one. We're going to look now quickly at a domestic law. The reason we're looking at this domestic law is because it has international effect. It's the law, the common law. Now, for those who know, I apologize for explaining this, but the common law is a system of law which originated in the UK and was effectively exported through the empire, and now is a system of law which is in the former in lots of Commonwealth countries. And it's not a codified system as such, it's a system based on precedent. And so the older the case is, then the more influential it is, generally speaking. And it doesn't matter that the case was originally heard in the UK, because the common law applies in other countries in various different ways. So the reason for having a look at this is it can be quite influential. And if you have a look quickly at the common law countries and its effect, you have this old case which goes back to 1576, which has established the principle of some elements of confidentiality. And this was not to do with a journalist and the source, but to do with a lawyer and the source. And the first common law case which established a principle of confidentiality between a journalist and their source was in 1888, the case of Hennessy and Wright, number 2. And in different ways, this remains an influential idea. There was a 2010 case in South Africa which described the idea of journalistic source protection in a limited area, in the area of defamation, as being particularly, as having been existing on the books for, quotes, generations. So it's quite, even by 2010, it was an influential doctrine. And it's still influential in other countries in the world, Australia, New Zealand, India, Singapore, and so on. Worth pointing out that it's not necessarily been followed in all of these countries, and in other countries like Singapore have interpreted it in a different way to other countries. A little whistle-stop tour about what the oldest source protection provision, leaving aside that 1576 case, which is more about journalists, more about lawyers. The oldest official source protection law is actually the Swedish one. The 1766 Freedom of the Press Act in Sweden had a source protection law. That's no longer good law itself. I think the 1991 fundamental law is more impressive. Okay, so what have I done now? I've just taken a whistle-stop tour through freedom of expression provisions in national, international, regional, and some influential national law. What can we take from this? What can we learn about the interrelation between the laws themselves and the activities? And by the way, I haven't been talking too much about rights because I didn't think I could fit it in, but I can talk a little bit more about rights if you'd like me to. What can we learn about this? I mean, the main thing, unfortunately, is it's quite complicated. If you look and analyze these rules, they are different in terms of who they cover. So do they cover institutional journalists, so people who are employed by an institution, or do they cover people who act as journalists, so bloggers and so on? They're slightly different. It's different, the laws are different about what activities are covered. So investigation itself, the finding out information, or the communication side of it. American source protection laws tend to protect only those acts of communication, while in other countries, it's protected just for the information gathering as well. And the laws are different in terms of strength. Some of our fundamental, the Swedish law is a constitutional law which has existed since 1766. And in other countries, these are quite weak laws, or even administrative provisions rather than constitutional provisions. So that was the first element of it's complicated. Here's the second. The second is that enforcement is very different around the world. There are very strong source protection laws in some Arab countries, but as I'm citing a previous author on this, Passetti, has pointed out that the enforcement of them is very weak. Secondly, I mean, this is the work, again, I did with another colleague, even in countries where one might hope there was a recognition of source protection laws, UK and America, they are frequently flouted, and they're flouted these days because of the ability of the intelligence and securities agencies to snoop on communications. So we've got areas where this becomes very complicated. So the laws themselves are complicated, and enforcement of the laws, moreover, they're changing. And this was work done in 2018, but the laws are changing all the time. I'm coming to the end of my time, so you'll be pleased to know I'm concluding here. And so what do we gather from all of this? We gather yet again, it's complicated. So spinning out from the particular of looking at international freedom of expression law and investigative journalism, looking at how they relate, what more could we say about the relationship more generally between laws and the activity of journalism? Well, I think going back to the approaches in the book, which I mentioned at the start, is kind of helpful. We need to think about these laws as norms. So we need to think about these laws as kind of things which control people's behavior. And we need to have a little thought about the ways in which these norms can influence behavior. They can prevent things from happening, as I said, and they can hinder things, and they create things happening. But there's another way of looking at them as well, and looking at these as counter norms. So you get some laws which do the things I said right at the beginning, but you get other norms which do these other things which I've got on the screen at the moment. It's almost like a sea, and there's lots of eddy currents going on at the same time. So that's my conclusion. My conclusion, if I can go back to it, is this slide here. It's complicated. When you're thinking about the relationship between norms or laws and an activity and rights, there's quite a lot going on. So there we are. Thank you very much for listening to me.
Thank you very much, Dr. Damari. Now we are going to join Dr. Javier Diaz-Nossi. I'll do a brief presentation first. Dr. Nossi is a full professor here at Universitat Pompeu Fabra and the coordinator of the DigiDoc research group. He is doctor in history and law, head of the project NewsNet, financed by the Spanish Ministry of Science, Innovation in Universities. His research interests are digital journalism, digital humanities and history of communication, inequality in digital media, copyright and digital media. And this year he published the book El Derecho de Autor y la Información de Actualidad. And today he will be presenting Negotiating with Google and Facebook, New Ancillary Rights for Press Editors and Journalists, the Spanish case. Go ahead.
Okay, thank you so much. I will share my screen, my PPT presentation. Please let me know whether you can see it perfectly. Thank you, Richard. Okay, I don't know if the topic is interesting. Probably it is for some of us, for some people here in the room, because some of them are specialists in copyright and the news. But at least it's very fashionable because this is a very recent news. The directive on copyright in the digital single market, which is compulsory to be implemented in every one of the 27 state members of the European Union, has been finally implemented in a very curious and weird way in Spain as well. And it will cause controversy probably in the very next future. So the title of my presentation is Negotiation with Google and Facebook. I mean, the law is not related to that directly, but in fact, in the background, it is. New ancillary rights, or maybe not so new ancillary rights for publishers and users and journalists. I never forget that we are in a faculty where we try to train future journalists, and the Spanish case. I'm not very concerned about the very local domestic point of view, but I need this as a study case to deal a little bit during the following minutes about the movement, the legal movements on copyright as affecting media industry and practitioners and even users. The movements are related, as I have explained, to the directive on copyright and related rights in the digital single market approved by the European Union in March 2019. You know that directives are to be implemented in every one of the 27 state members of the European Union. So they have the obligation of enacting those legal provisions in the domestic law, in the national law, and the capacity of adopting and to some extent adapting those legal provisions, which finally in November this year, I mean, this very month, Spain has done. And this is related to some other legal movements around the same topic in some other countries all over the world, especially common law countries. And the most relevant one this year is Australia, which in March this year has passed the News Media Bargaining Code, a very controversial code trying to oblige to negotiate, especially Google and Facebook, which is probably the point of all these legal movements. So finally, Spain have managed very late. I mean, the deadline was surpassed to implement the provisions of Directive 2019 of the European Union in our national law, especially two articles very relevant, Article 15 and Article 17 of the European Directive. Article 17 is the one we are particularly interested in this conversation because it's related to allow new ancillary press publishers' right, affecting obviously the practice of journalism. And it is related to another economic movement, especially in Europe, in continental Europe, also in the UK, and previously in the United States of America, a movement through a new readers' revenue model of financing the digital press, meaning membership models like the one by The Guardian or in Spain by El Diario.es, but especially paywalls, different ways that have been implemented, have been established, especially during these last 2 years, starting especially from the pandemics onwards. So since many great media publishers, especially newspaper publishers, are trying to make people pay for the news, putting paywalls for the news, very strict ones or not so strict ones. At the same time, they are lobbying in a very intense way in the European Union, especially, and in other countries as well, like Australia, in order to reform the copyright law, so to incorporate in those copyright acts a particular right for press publishers. I've recently published this book, which tried to go beyond my PhD dissertation in law in 2016, trying to show which is the picture right now. But the question is that the picture reflected in that book and in this report, both of them, I'm afraid, in Spanish language, both of them need further revision because of the new implementation of the European directive. I mean, the intention of all of those legal movements all around the world is to make Google and Facebook pay. The target in Australia was not also Google, but especially Facebook. Facebook struggled a lot and finally managed to make some convening movements to the final writing of the News Media Bargaining Act in Australia code in Australia. But in Europe, and especially in Spain, the target is Google, because as you probably know, when the last reform of the Spanish intellectual property law Copyright Act actually happened in 2014 to be enforced from January 2015 onwards, Google News decided to drop its service in Spain. So we haven't had Google News in Spain from that point onwards. Immediately when the latest reform on the intellectual property law in Spain has been approved, Google has announced that they will be back in January 2022. I mean, in a month. Probably it won't be Google News. It will be the new service Google Showcase, which is another movement by Google. So we have to take a complete picture of it. It's not only the legal reforms, the legal movements, it's also the economic movements in media industry in Europe and in the world, and it's also the movements that Google and other giants from the United States, Facebook and so on, are doing as well. And it means that finally Google has managed to negotiate with the new Spanish government and with at least some of the most important media groups in Spain after the failure of Article 32.2 of the so-called Texto Reformado de la Ley de Propiedad Intelectual, our Copyright Act, that was enacted in 2014. At that moment in Spain, there was a right-winged government by the Popular Party, and the greatest media groups in Spain managed to oblige to some extent the government to accept those movements. But they didn't manage to make Google News pay. Actually, Google News went away. Probably I will translate it for you. Since Google News is coming back, in Google News or Google Showcase, the new product by Google, it will mark the media agenda in Spain and probably in Europe in the next year. Okay, so we need to follow it very carefully. We're using here comparative functionalist legal methods, meaning that different legal instruments are being approved all over the world in order to pursue the same goal, which is to make Google and Facebook pay something because they're using the news produced by some other people and some other companies. In Spain, it was very curious because the legal instrument chosen with very limited effect and very unsuccessful, in my opinion, was an unwaivable right. This is perfectly okay in legal terms. It's perfectly possible, but it was very surprising to make a neighboring right, an ancillary right, an unwaivable right. I mean, media companies, even if they wanted not to be paid in exchange of Google News using their news, were obliged by the Spanish law to do so. As a result, immediately, once Google News went away, many media groups, especially Prisa, the one who publishes El País, which is one of the most influential and most widespread read media in Spain, complained, and probably they started moving away to negotiate with Google. After the latest reform in November this year, this unwaivable neighboring right is no longer in effect. The way that the European directive has been implemented in Spain is quite surprising, and is characteristics of some civil countries, especially those who are inspired by the French legal system, which is the decree law. The decree law is a law approved by the government and not by the parliament. In this case, the reasoning behind that decision is that Spain was late in implementing the directive, so they needed a very quick response to it. And the criticism that has arisen is that it avoids discussion in the parliament. Anyway, the right-wing party on the opposition, the Popular Party, hasn't complained so much, so probably it will go into effect and no further complaint will happen. Even surprisingly, that decree law was not especially about copyright law. It was a so-called omnibus decree. I mean, it was a governmental decision comprising many aspects of different, very different legal branches as well. So it's to be discussed whether it's the best legal instrument in Spain. Some other European countries haven't done like that. They have gone to the parliament, which is, in theory at least, if we accept Montesquieu's division of powers, the best way to do so, to modify it. Even we need to see what happens with Cedro's legal suit. Cedro is the main collecting society in Spain and the one in charge of collecting the so-called Google tax, the one in charge of making Google pay. Cedro decided at some point in this year to go to court against Google, saying, okay, Google Discover, which is another product, probably you're using it all the time in your mobile phones, is a hidden news aggregator itself, and news aggregators, according to the Spanish Copyright Act, need to pay to Cedro. Let's see what happens with that legal suit. Probably Cedro will be obliged to take it back and know to go forward. Actually, my point of view is all these legal movements, I mean the ones in continental Europe and even that one in Australia, are acts trying to favoring or obliging to negotiation for the great American giants, namely Google and Facebook. And negotiation seems to be the key word of all those legal movements. I mean, they have double-checked that obliging Google to pay is not the best way. It wasn't the best way in Germany. It wasn't the best way in Spain in 2014, 2015. It was absolutely unsuccessful in economic terms. So they have preferred to make some acts or reforming the pre-existing acts in order to favor negotiation with Google and Facebook. We have also, in this respect, negotiation, the French legal movements, both at the parliament and both in courts. I mean, Google negotiates with the French press editors all the time, and they're doing so, obliged by the Supreme Court in France this year as well. We have the Dutch model. The Netherlands are a European Union country. Theoretically, they are a civil law country, but especially regarding copyright law, they are a mixed country. I mean, they have adopted many provisions and many legal instruments from the common law legal tradition, which is great. So we need to pay some attention about what's happening in France, in Australia, and in the Netherlands, most probably. Then we have the Australian model. Okay, they haven't reformed the Copyright Act. They have preferred to enact a new code about a very specific part of negotiation between Google news aggregators and the media publishers. Let's remember that one of the most powerful press publishers all over the world is Rupert Murdoch, and he's from Australia. In Spain, this latest legal movement, let's see what happened in the next future, gives freedom of negotiation, which is a crucial point in civil law, actually. So they have moved to that. So let's people negotiate by themselves, okay? We just will give some shelter to it. So freedom of negotiation seems to be one of the keywords. But related to that, and I think that in Spain we are not very used to that, but will be in the next future, it will bring confidentiality clauses. I mean, since Google is negotiating with everyone, not all of them. Google is negotiating with the main media companies and groups in Spain. The terms of agreement will be very different, and the compensation, the economic compensation probably will be very different. And most probably, Google will be very interested in covering it with confidentiality clauses. So as researchers, we won't be able to make great progress about knowing which are the terms of those negotiations and which is the economic result of it. But we can probably guess that there will be great differences. Actually, they're happening. Even because Google is negotiating in national terms, but in international terms. One of the examples that Unidad Editorial, who is the group publishing one of the most important newspapers in Spain, El Mundo, is owned by an Italian trust. And even though if the Spanish Unidad Editorial company was against this movement, the Italian owners were in favor, and they have obliged the Spanish division to accept negotiating with Google. So we have to take a greater picture of it all. And the news publishers in Spain, especially those interested in negotiating or actually negotiating these days with Google, say that it will be okay because they will be able to oblige Google to be transparent about changes in algorithms, because one of the key points is to which extent Google and Facebook classified or rank the news, okay, to which extent the news produced by those companies and behind them by some authors, I mean journalists, appear in better positions in Google News or Google Discover or in Google Showcase in the next future. So this is a picture, and we need to see what happened. We have so far the celebratory approach. Celebratory approach tells that it will be beneficial for traffic, probably it will be. It's perfectly okay for small media. For instance, for El Diario.es, which is one of the few ones in Spain which have adopted the Guardian's model of membership instead of subscription and paywalls. That will be okay. They're in favor. Probably will be beneficial for some great companies. I mean, for the ones able to reach good agreements with Google and Facebook. And probably would be beneficial for users because they will be able to use, again, Google News on, in this case, Google Showcase. The great question is what happened with journalists, what happened with practitioners, because this new ancillary neighboring right is specially intended or created for news publishers, which in the civil law countries are not considered authors of the intellectual work. The only possible authors of intellectual work in civil law countries like Spain are individuals. I mean, in this case, they are journalists or photographers or infographists or so on. I mean, people normally hired by media companies to produce intellectual work. The directive, the European directive, mentions compensation. Let's see to which extent this is incorporated in legal terms in the Spanish Copyright Act, and most especially in practical terms, to which extent journalists and association of journalists manage to get proper compensations for the use that Google is doing of the news published by their employers, right? I mean, the employers, the companies will get some very good, in some cases, economic compensations by Google or Facebook. Let's see what happened with journalists as well. And that's a very interesting point in our faculty, since we're training future journalists. Some great groups, namely PRISA, are very in favor of it. Actually have published in November an editorial piece about that, saying, oh, it will be a very, very good, very convenient for the digital landscape, media landscape in Spain. Let's see what happens. But instead, the situation is that obviously more than 30% of the traffic derives from Facebook, actually. So it's good, theoretically speaking, to be in good terms with Facebook and Google. This is interesting. A new report by Facebook itself confirms that news more consumed all over the world are those related to entertainment, not hard news, but soft news, so to say, right? And that the most consumed content in Facebook, probably the same thing in Google, is that one shared by friends in some other social networks owned by Facebook, namely WhatsApp. I think this is a thing to be very carefully considered. This is the report, the last one by Facebook. I think this is a very interesting one. And on the other hand, we have the non-celebratory approach to the new legal reforms. Probably Google will pay only 30% of the clicks. So 70% of the clicks are lacking or not paid, not compensated. And it will mean, some very initial calculation mean that it will be 5% less that, for instance, in Germany or France, countries which have implemented the European directive before Spain, and probably in a better way. And it means 20 million euros less for the media publishers in Spain. In Spain, differences appear between great media companies. The smallest one are in favor. Some of the greatest one are in favor as well. Some of the greatest one are absolutely against it, namely Vocento, which is probably the greatest regional trust in Spain. Grup Godó, the one who publishes La Vanguardia in Barcelona, is against as well, is absolutely against that. They prefer the compulsory regulation of 2014-2015. And let's see what happened with the main lobbying group, great newspaper publishing lobbying group in Europe, namely News Media Europe. Behind it in Spain is Vocento, which is against the reform, saying, okay, it's time to implement the European reform, but let's see what happens in each member state of it. In our case, let's see what happened in Spain in relation with some other aforementioned models as well. This is from just today. Actually, Vocento is more and more against the reform. They probably struggle against it. And even some journalist associations in Spain are, if not against, doubtful about what the influence of such legal reform of the copyright law in Spain will affect, or may affect, freedom of speech, actually, because one may think that if Google negotiates with a media group and pays for it, maybe Google can say, or Facebook can say, okay, but we are interested in you informing about us or about our partners or about this sector in these terms, and please avoid to inform about that in some other terms. And it means a clear limitation of freedom of speech, or it can happen. Let's see what it really happened. The greatest newspaper publisher association in Spain is cool about that. See, because some of their members are in favor, some others are absolutely against. So there are something in the middle, but Clave, which is the one which groups the smaller newspaper publishers in Spain, are absolutely in favor. They've always been, especially 20 Minutos, which is the main free press in Spain, and eldiario.es. By the way, eldiario.es, the editor-in-chief is Ignacio Escolar, and the editor-in-chief of 20 Minutos is his father. Okay, this is the situation in Spain. We are far from the situation, for instance, in France, because regarding to journalists, we have a very weak practitioners associations or trade unions, which are the key point in France. For instance, in France, news publishers negotiate in good terms with Google, and then journalists negotiate in good terms with their employers. And the lines can seem to be much more balanced than it is in Spain, for instance. So finally, some questions arise. I don't have an answer so far because the reform is so recent. First one, maybe Dr. Richard Damari can help us to answer that. Is an ancillary right or a neighboring right the best way to make Google or Facebook pay? Is it the best way to be a solution to the great crisis of printed newspapers? I'm very doubtful about it. Is it a good complement for reader revenues? Because we are in front of a great movement from financing of the press based on advertisement to reader revenues. Seems to be the main strategy in Europe and all over the world. We need, news publishers need reader revenues. They need the readers to pay for it in some way, direct or not. And the question is to which extent this new ancillary neighboring right for press publisher will be beneficial for journalists, and for instance in Spain, will they be able to achieve good compensation from the companies and from Google directly. And probably my suspicion is that we'll see unequal agreements and probably an increasing unfair competition. One of the key points is that we are trying to regulate it using copyright law, but most probably it will be more effective to concentrate on fair competition law. Because unequal agreements between Google and Facebook and the different companies will lead us to a very controversial situation. And finally, and related to the amazing conference delivered by Dr. Richard Damari, will it have an impact on freedom of speech as well? Will Google or Facebook make some pressure, some lobbying activity in order to get some special treatment on sensitive aspects of information in exchange of accepting to pay for the use of using their aggregators? And I think this is a very good question. I'm not able to give a proper answer so far, but I think we need to start thinking about that. And at the end, will be a solution for the clear dominant position of Google and Facebook and so other American giants. And we'll see that whether to which extent a diversity of media's response is the best way to balance that huge dominant position by Google and Facebook, which is a major concern for the European junior legislators. So far, this is my humble speech. I'm willing to be able to answer or discuss any questions you may have. Thank you very much.
Thank you very much for your presentation, Dr. Diagnosi. Now we will stream Dr. Antonia Nogales Bocio's presentation. She is not able to join us today due to some personal inconveniences, but she was kind enough to send us a pre-recorded version of her presentation. So I will give a small bio, and then my colleague Priscilla will help me with the video. Dr. Antonia Nogales Bocio is a professor at Universidad de Zaragoza in the area of audiovisual communication and advertisement. She's a doctor in journalism, and she's the vice president of LADECOM, Laboratory in Communication Studies, and she is also a member of GRECO, a research group on communication structure, history, and content. Her research interests are the history of Spanish journalism, the structure of information, communication and power, and audiovisual discourse analysis. She will be presenting, her video will be on low journalism, slow journalism, and human rights, differences and risks in their coverage, on the news coverage, of the migratory phenomenon in Spain. And Priscilla, if you're there, thank you.
Hello, good morning, everybody. I'm Antonia Isabel Nogales Bocio. I'm a journalist and I have a PhD in communication from the University of Seville, Spain. I'm currently professor at the Journalism, Audiovisual Communication and Advertising Department of the University of Zaragoza, Spain too. First of all, many thanks to the organization of this lecture series, Intersections Between Journalism, Law and Rights. Thanks to the Department of the Communication of Pompeu Fabra University and to Brunella Tedesco, especially for the invitation. I would have loved to have been able to be with you alive, but unfortunately my academic and family commitments have not allowed me to do so. I am very sorry for that. I am going to share my presentation and I hope it looks right. Well, let's get going. This morning, I would like to tell you about low journalism, slow journalism, and human rights, difference and risks in the news coverage of the migratory phenomenon in Spain. This research was published in 2020 in Inclusion's Journal, issue 2, volume 7. I analyzed the coverage of a case study in 3 traditional media and 3 digital newspapers, specialized in social journalism. As said, August 2019, 155 migrants managed to get into Ceuta in a massive jump to the border fence, the first for more than a year. During this event, 16 migrants and 11 officers were injured. The treatment was being mixed. I invite all of you to read the full text that is available in internet. And in the next 15 or 20 minutes, I will try to be brief, I promise. I will try to explain the main ideas of the general approach of this research. Well, I belong to the Digital Communication and Information Research Group, HITID, attached to the University of Zaragoza, to the Research Group on Structure, History and Contents of Communication, GRECO, attached to the University of Seville, and the Research Group on Social Media, Inclusive and Ubiquitous Education, SMEMU, attached to the National Distance University of Spain. I am also president of the Laboratory of Communication Studies, LADECOM. Well, let's begin with some ideas that I consider key to start with. From journalism crisis to the crisis of journalists. Journalism has been a law-making profession since its inception, but today there is also a crisis of credibility and prestige to the traditional media. People don't trust the media as they used to. The current context of journalism is conducive to a trend towards low-cost journalism. The economic crisis and crisis of values in journalists today is coupled with increasingly tired and underpaid journalists in newsrooms around the world. In the commitment to slow journalism, it's necessary to analyze the concept, the main characteristics of the phenomenon, and the journalistic routines or key factors that condition it. Slow journalism in migratory phenomenon. In this new environment, slow journalism provides that transversal, critical, and relaxed vision that is especially crucial when it comes to reporting on events related to human rights, such as the phenomenon of migration, obviously. Analysis of concrete examples, case study. We analyze the existence, context, and main characteristics of low and slow journalism in relation to this particularly sensitive and relevant topic, migration. In this sense, we proceed to the comparative analysis to several current events in order to detect the difference between the low coverage carried out by the majority of the media and the slow treatment of slow journalism. The main hypothesis is that low journalism puts at risk the human rights discourse, the human rights speech, while slow journalism can favor its development and expansion among citizens. I invite you again to consult the full text, as here I will only focus on some features of the research. Finally, the conclusions relate to the taxonomy of slow journalism on human rights issues. Well, in the current context of information globalization, journalistic practices are reproduced among the media motivated by emulation in professional news routines and by the speed with which news events are covered. The lack of reflection and depth in contemporary journalism strengthens the professional discredit and distrust of the mass media, as well as the rise of increasingly dangerous dynamics such as fake news and the trend towards post-truth. The media is not only a source of concern, but also of hate speech in the area of migration. Well, in tune with the macro-structural economic crisis that began in 2008, there is a trend towards low-cost journalism, which aims to achieve maximum profitability through the systematic and multi-channel repetition of contents, the absence or depth and analysis in the coverage of the facts. While newsrooms are shrinking, the space for interpretation and analysis is shrinking in the mainstream media. At the same time, initiatives for slow journalism are emerging. Yes, low-cost journalism brought about by the current condition of mass journalism is characterized by immediacy and fast consumption, the maximum profitability, the profitability of clickbait, for example, and a multi-channel repetition of content, the lack of depth, and the lack of analysis is a fast food information, you know. A public opinion feed fed with low quality information is an easier victim of disinformation. Disinformation is a key tool in the speed or hate speech. Causes ignorance, contempt, and fear towards a target group through distorted or false messages. In this context, there are difficulties for quality information, crisis of journalism, loss of truth, etc. And all of this degenerates into manipulation of public opinion. We have to remember that disinformation, both as a concept as a practice, is a process conscious, intentional, that pursues an end and employs manipulation, deception, or misleading, and in pursuit of a benefit, economic, political, or ideological benefit. The aim, the realization of a discourse that arms the political adversary or target groups. Disinformation is precisely one of the main workhorses of mass communication today, with political specialization being one of the most recurrent in the appearance of fake news. From the censorships due the hyper-information described by Umberto Eco, or the intoxication due to information overload on the internet coined by Alphonse Corneilla. The truth is that fake news proliferates nowadays with particular ease. Well, when disinformation and human rights discourse come together, cyber hate is born. Cyber hate or online hate speech is a central scientific and social issue. In recent years, growing polarization and radicalization are present in social environment in several dimensions. Media discourse reflects this. Cyber hate is hate speech against the others, against outsiders or enemies, which includes offensive, insulting or threatening text, speech, videos or images against people because of certain characteristics of the group to which they belong, their sexual orientation, disability, ethnicity or religion, in order to bully or jam them. This is a research of Watch and Write in 2019. Well, the space for reflection and interpretation is diminishing in the traditional media. At the same time, new initiatives are emerging to counteract loud journalism with a commitment to slow journalism. In response to censorship by hyperinformation or intoxication generated by the dizzying pace of the news production cycle in a digital era marked by the multiplication of new operators, among which social networks stand up. There is a growing demand for transmedia content. About slow journalism, as you can see in the graph, in slow journalism are present a transversal vision that allows us to understand how the elements fit together in the interpretation of the facts. It's similar to complex thinking applied to journalism. Second, a critical and relaxed view. This is essential for the public to form its own opinion. Time is essential for this too. Increasing credibility, a journalistic product that has verified sources, quality information, in-depth interviews, and expert analysis can be trusted. Only a few media produce that feeling, specialized media that take their reporting seriously. And an increase in the quality of information. Quality information takes time. It doesn't come quickly, and it isn't quickly consumed. It's impossible. In Spain, in this line, it's worth highlighting the presence of media such as Periodismo Humano, born in 2010 by the Pulitzer Prize winner Javier Bauluz, La Marea, a daily digital media. It also has a monthly magazine on paper, yeah, read it by Más Público Co. a cooperative of readers and workers that was created in December 2012 after the closure of the paper edition of the newspaper Público, and Otro Periodismo, digital magazine specializing in social issues, are Infolibre or Salto. Yep. These are transmedia contents that opt for explanatory and interpretative journalism and tend to resort to the news genres most closely linked to a lengthy word process and expert thematic positioning. In this sense, we detect a tendency to recover genres such as reportage or analysis, to which transmedia elements and complementary infographics resources of our own creation, sorry, are usually incorporated. Yeah. It's very interesting. Well, this is an example. Transmedia productions are a very favorable field of work for slow journalism, because the incorporation of additional context interpreted by the professional information provides extra knowledge that moves away from fast consumption journalism. For the commitment to a slow journalism is essential for journalists to learn media skills. Therefore, project-oriented training and the creation of platforms such as Entremedios at the University of Zaragoza, where journalism students can reinforce this learning and promote quality journalism, are so amazing, these initiatives. Well, and some conclusions to end. Low-cost journalism applied to particularly sensitive issues negatively affects human rights. This manifests in despersonalization and reification of the protagonist of the news, presentation of migration as a problem, not as a situation that human beings are going through. This is an evidence of an Eurocentric vision. Yeah, and this is a problem. And this is a problem. This is one of the problems. The presence of metaphorical words and terms such as plows, wave, avalanche, others such as massive arrival, migratory pressure, drama, refugee crisis, repel, contain, problem, etc. Well, in this media, there is often the presence of use of agency information, distancing of the journalistic from the scene of events. Yeah, the journalists are to separate of the events. Lack of context, presentation of the event in isolation motivates the lack of interpretation and interrelation of phenomena. And linear discourse, lacking complexity, lack of understanding of the phenomenon. Yeah, punctual coverage, not informative follow-up. This reinforces the projection of the event has a problem. On the other side, yeah, on the other hand, slow journalism provides a critical view of power, all kinds of power, is analytical, in-depth, use transmedia elements with an analytical intention that's not merely descriptive one. Yeah, it will use more disused genres such as reportage or analysis. Greater respect for the individualization, personalization of the news protagonist, absence of criminalization speech and use of terms with negative connotations such as invasion or waves. Greater diversity of sources, properly working with sources takes time, and respect for the ethical principles of journalism, such as truth, justice, responsibility, and engagement to public opinion. In sum, it strengthens the discourse of full respect for human rights. I want to remember that this research is carried out by the Digital Communication and Information Research Group, recognized as a reference group by the Government of Aragon and financed by the European Social Fund for Regional Development, FEDER. And in the present, I enjoyed this research very much, and it opened up an important line of research for me. In fact, this year I am developing a research project funded by the Seminario de Investigación para la Paz Foundation entitled Irregular Migration and Media in Spain, a guide to good practice in the production and consumption of information. In this project, I am researching the presence of fake news related to irregular migration in 3 Spanish verification services and the effects of misinformation about this issue on citizens. I found 99 news items verified as fake in Maldita, Neutral, and F Verifica between July 2020 and June 2021. Many of these news items provide a dangerous view of migrants. It presents them as a sector that enjoys greater privilege than Spaniards. It also presents them as responsible for crime and an increase in criminality. These fake news stories are sheet-faced than verified information and put the discourse of peace at risk. Well, thank you so much for your attention. I'm sorry I couldn't be with you live, but I'll leave you my email address so that you can contact me if you wish. I will then be able to answer any questions or comments. Thanks so much, and see you again.
Thank you very much, Priscilla, for sharing the video. Now, and thank you to the presenters for all their very interesting and talks. I think we've covered a wide array of well, these very intersections as the title of the talk indicates. Now, if anyone has any questions, we can invite you to either activate your microphone and your camera, with the reminder that the session is being recorded. And if you don't want to be in the recording, please just share your question to the chat and I'll read it out loud. If anyone has a question, please go ahead. Yes, Dr. Antoni Rubi, go ahead.
Okay, thank you. Thank you very much for all the interesting presentations. I have some few questions for Richard. First for Richard. Richard, I really enjoyed your presentation, your talk, and I agree with your conclusion that looking into the laws is complex, especially because, as you pointed out, their enforcement may result in these stark differences between the law on the books and the law in action. Even if I am myself a legal scholar, I tend to believe that for understanding some social phenomena, law is just one of the explanatory factors, and maybe not the most relevant one in many settings. We have to take into account other aspects, such as the market structure, culture, the social norms in place, and so on. And so here's my first question for you. I would like to ask you about your views about the influence of law on investigative journalism vis-a-vis other factors such as culture, media ownership, or the public funding of media. So, for instance, we know that in some countries like England and the US, there is a strong tradition of that embraces and promotes investigative journalism, and this tradition is not present in other countries. unfortunately. And also we may anticipate that if a publisher really depends, economically depends on government's funding, it will have fewer incentives to promote investigative journalism of corruption. And my second question is somehow related to the previous one. I would also like to know, or I would also like to ask you, whether in your approach, rules on media ownership, on public funding, or employment of journalists, of professionals, would be rules that allow to create this infrastructure for investigative journalism.
Thank you very much. Sorry, the pause there as I struggled to find my off button, my microphone button. So I completely agree. When you're looking at any activity, there was a huge interplay of different factors which either encourage or dissuade it. Law is one. In different countries, it's more powerful than others. I think the key insight with investigative journalism, which also applies to something which Javier said, I think in passing, when he was pointing out that the thing which the Spanish publishers found was most valuable was soft news rather than hard news. I think that leads to a key insight in this, is that investigative journalism is what economists frequently call a public good, in the sense that the amount which people will pay for it doesn't correspond with the value it provides to society. Similarly, the extension of the point is the amount of people who read investigative journalism or consume it or watch it doesn't necessarily correspond to the threshold you need to get for it to be an economically viable activity. And that leads to some problems. Historically, that problem has been resolved economically by people selling lots of soft news, and that cross-subsidizes in financial terms the provision of investigative journalism. Non-economically, but in terms of the economics of attention, people didn't pay too much attention. They wouldn't buy a newspaper in old money for investigative journalism. They'd buy it for the latest news about a pop star, and then in passing, they'd find out about the investigative journalism, they'd read about that, and therefore they would consume it. So that insight, I think, is important to bear in mind to answer your question about what is the most important factors. And I think there is a number of them which encourage them. Public funding, to take the first one, is important, but it's connected with another point you made about cultural attitudes. In some countries, public funding works. In other countries, it doesn't. So in the UK, we have a tradition going back to Lord Reith to 1920, late 1920s, 1926, around about then. Of the acceptance of money which ultimately derives from the state, but with a resistance to any control on that state. At the time of what was called in 1926 the General Strike, Winston Churchill tried to get the BBC to follow the government's editorial line, and the leader of the BBC, Lord Reith, said he wouldn't. And Churchill said, "But I'm not impartial as between the fire and the fire brigade," as an argument saying that there are limits to impartiality. I think that sets the cultural attitude which has persevered in the BBC for the fact that it can accept public funding and be on the BBC and still do an impartial investigation into the agencies of the state. Interestingly, the same sort of funding model was translated to the Japanese public broadcaster after the Second World War. And there's a guy called Henry Lawrence who's done some research on this. And it didn't lead to the same response. So the cultural attitude there is that the public service broadcaster is much closer to a state broadcaster. So public funding works, but it works in some countries and not in others. So I'm agreeing with ultimately what you said, is that this is complicated and it's not about law, it's not about public funding, it's also about cultural attitudes, which makes it difficult to find a solution. In America, the solution they tend to have gone for is philanthropy supported journalism. So people give lots of money to it. And in fact, the Washington Post is a good example of that. You've got Jeff Bezos, who is in fact supporting the Washington Post, and he's bought it. So despite the fact it runs a loss, it still works. In the UK, we've got some examples here. For example, the Bureau of Investigative Journalism, which is supported by the man who made lots of money from a handheld computer. Your second question, Yes, it is. It's quite difficult. The media ownership rules are absolutely crucial in terms of constraining the influence of, and again, mentioning something Javier mentioned, Rupert Murdoch, for example, restraining the influence of people who have too much command over the megaphones of public talking. Whether it has an effect on investigative journalism, I think it probably does, but it's more complicated to work out how, given the fact that there is an argument that if you allow people to make lots of money out of journalism, then they will have free money to spend on investigative journalism. So that would be an argument which newspaper owners would say suggests liberalizing media ownership laws. My reaction is I don't think that's a good argument, because I think that the potential cost of warping political debate is greater. So I think that wouldn't be a reason to liberalize media ownership laws. I hope that answers your question.
Dr. Diagnosi has raised his hand.
Yeah, thank you. If I may, I agree with both of you, with Antonio Rivera, Richard Danbury. We have to take a greater picture of it all, because law is just one part of society, actually. And even we have to make a legal analysis in a transnational perspective, because there is an influence of some, as Richard Danbury has posed, some very influential domestic national laws in other countries as well, and in other legal traditional systems as well. So we are not on our own. Sorry? So yeah, I agree. We need a more transnational perspective, and I love to mention you have done, Tony, to law in action. Law is not a thing which remains on the paper exclusively. We need to be just the practice and the practicality of it all. For instance, the reform of the Copyright Act in Spain in 2014, 2015 was absolutely useless. I mean, they were expecting to collect some 80 million euros from Google, and they collected from other news aggregators 10,000 euros. So it's absolutely useless in economic terms. Besides, we are talking about some legal movements in intellectual property in copyright law, but we are not considering competition law, which is very important in my opinion. I mean, legal branches are not alone. They are related. Probably the structure of our university doesn't help to make real conversation between the different branches of the law, let alone a conversation between the law scholarship, and other branches of social sciences and the humanities, in our case, communication. So absolutely, we need it, absolutely. And then, besides, we're talking about public good. I mean, the discourse of news industry is that they produce a very publicly valuable good, which is news, but instead they are private companies all the time, because we are not talking about how to subsidize public broadcasting services like BBC or the Catalan television or the Spanish public television. We are talking about how to help private companies, meaning newspapers, whose crisis comes from the printed world, which is absolutely dead, in my opinion. Besides, in some parts of the world, like Catalonia, we need to talk, and we need to decidedly talk critically about subsidies and institutional aid, because this is my opinion, laugh now, cry tomorrow. Okay, subsidies are okay during a period of time because they can help an economic sector in crisis, but they can't be forever, and they can't be one of the main sources of financing the press. They can't be. And in my opinion, we need to take a greater picture of it, relating many aspects, even as in our last talk, about how the different practices in journalism has an influence on the way that we are financing the sector, meaning that Google and Facebook are clearly privileging, and maybe the public, the audience is clearly privileging some soft, entertaining news products instead of more developed, slow journalism, in-depth journalism, investigative journalism, and how it can affect the freedom of speech and the good conditions in for journalists, because at the end, news are produced by people who need to make a living out of this activity. It's not to cover the industry, which is okay. We need to cover the people who are hired by the companies to produce those contents.
Thank you very much. I don't know if someone has anything else to add in that regard. If not, we have a question in the chat. It's an open question, so anyone can really answer it. What do you think about Meta regarding journalism? Well, Meta is this conglomerate rebranding of Facebook. I don't know, Dr. Diaz-Nossi made a gesture. I think he has things to say about it.
In legal terms, let's see what happens with Meta, with Metaverse, especially because if it's a virtual world, it can involve such legal areas like intimacy and privacy and identity issues and so on. So it's a very, very good question, which probably will deserve another seminar like this one devoted to concretely that.
I just said to the contrary, I think it is one of the interesting things, because Javier was talking about copyright. One of the interesting things about Meta and at least the multiverse, or what is it called? No, not the multiverse, anyway, going online.
The metaverse.
Thank you very much indeed. The metaverse is so if you have a whole series of interactions and activities which are facilitated by a computer program, who owns it in intellectual property terms? Is the person who created the platform on which it exists? Do they own it? Do the people who are interacting with each other, do they own it? And you have beginning to some sort of conflicts between the European or and the Anglo-American conception of intellectual property there too. Is this about monetizing the intellectual product you've created, or is it about some sort of concept of the intellectual product being an extension of your personality and an extension of your intellectual creation? They lead to slightly different ways. If we're on the metaverse and Javier and I are having a conversation with our avatars about Anthony, and we are talking about, I don't know, the latest recipe for something or the other, who owns that? Is it because it's facilitated by them, it's Meta, or is it because we're talking about cookery, therefore it's an expression of our own personalities? Is it something? These are interesting questions. I haven't got the answers to it, but they're worth chewing over.
Excellent. I don't know if anyone else has any questions, or if the presenters have questions for each other. That's also a possibility.
It is absolutely true that metaverse, when it really exists, because it's wishful thinking so far, can pose very deep questions about intellectual property and copyright in particular, because right now on the internet, some digital objects, art, for example, and probably Anthony Ruby will have a better opinion than mine about this specific topic, are being sold. What happens with intellectual works that are produced only in digital form on that announced metaverse platform? And what happens with legal alternatives, because Facebook is particularly restrictive in that sense, more than Google even. Facebook is an American, a US-based company applying US very restrictive law about intellectual property all the time. So far, at least, it won't be better when metaverse is really implemented its reality, if it is eventually.
I think it's quite interesting because you've got the arguments which Javier eloquently described about what happens when social media capture the traditional business model of one sector of community, one sector of information propagation, which is journalism, which in effect is what they did. They destroyed the business model, which has existed in news since 1720, which is what all these discussions about. 1620. So what happens then? So if we do move to the metaverse, you've got the same thing happening again. You've got if Facebook managed to do it, they capture the business models of other forms of human interaction. So art is one. What happens then? We're going to have the same sort of discussions as we're having in relation to the press publishers' right, if it all works, 10, 15, 20 years down the line, when they capture the business models of other sections of the community. So art is one, interestingly, non-fungible tokens. And Javier's suggestion makes me think a little bit also about the droit de suite. In other words, the right of an artistic creator to claim a proportion of any subsequent sale from the sale of their artwork. It was a French idea which is incorporated in UK law through the EU and in other countries as well. So what happens there? Does Facebook, can that claim a droit de suite to any subsequent financial translation on the grounds that it's created by this work of art, which is arguably what Facebook is doing, as well as creating this technological thing? It's very interesting questions there. And I think the sort of stuff which Javier was talking about will give us some sort of insight to how to approach these questions if they do arise in 5 or 10 years' time.
Yeah, I don't know if Antonio Rubí is around, because he's not a specialist on artistic intellectual works. So maybe he can.
Well, I really don't have anything to add to your previous comments. So I think Javier and Richard have already pointed out some of the most interesting problems and challenges that the metaverse will pose for copyright law. And so we already have quite an experience on virtual works, on some digital assets, digital properties, creative works that have been that are native in the sense that have been created in a digital environment, and so far we have some knowledge about that. This year, especially during this 2021, non-fungible tokens are like a hot topic, and they pose lots of interesting legal questions from the perspective of intellectual property and copyright law specifically. And particularly, I think the point that Richard raised about the droit de suite, the resale royalties, and to what extent those platforms may create like a informal or an alternative droit de suite system, which works along the legal one established in the directive and implemented in all EU countries. I think that's a very interesting issue and a challenge for copyright law scholars who are interested in art, who are interested in technology, information technologies, and so on. I think there's a lot to say, and Javier, you are invited to organize a workshop on the metaverse.
We'll do that. Don't worry, you will be invited. You're we.
Thank you.
Hopefully, we'll try to do it presentially in Barcelona. Okay, I'm coming back from the United Kingdom next week, and I will be placed there, and hopefully we will try to do so. Even I don't know if you have already mentioned the question of derivative works on the digital environment, which is very great concern. Derivative works are okay because they are very creative. In my opinion, the European Union hasn't managed to regulate it properly, but they need to do so. It's only Canada and some other countries who have tried to some extent to do so, but this is a very dynamic verge of creation and recreation. I mean, users can recreate content or can derive content, and that's okay if it's properly managed, even in legal terms. And probably metaverse will be a challenge for it all.
Excellent. Well, if no one else has any questions, we can wrap up the session. Thank you very much to all the participants for their very interesting and enriching talks, and thank you for this this discussion, which kind of became a talk in itself. And thank you to all of those who joined us today. And we'll see you on the next core session. Thank you all for joining us, and have a great day.